Good morning, everyone. Thank you for coming to our 2022 Tenants Introduction to Rent Control seminar. This is one of several seminars that we present during the year. We did one earlier this week it was targeted toward property owners. We also do a maintenance seminar in the fall with the Code Enforcement Division of the city. And we participate in the landlord-tenant forum that is put on by the city attorney's office at the end of the year. If you are interested in attending additional seminars, just look for information from us in the newsletter that we send out, or you can check our website, and we'd be happy to have you join us for more presentations. So today, if we go to the next slide, just introduce myself. I'm Dan Costello. I'm the Public Information Manager for Rent Control, and I am here with Micah Michalski. He is one of our information coordinators. So here at Rent Control, we have a staff of people, the information coordinators and analysts who meet with members of the public like yourselves, or they are the ones who answer the phone and can answer your questions by phone or by email. If you email your questions to us at rentcontrol@santamonica.gov. So we have quite a presentation for you today, so let's go right into the content. Today's topics include first of all, what rent control overview, what the agency does, what the lawful rent is, which is very important to all of you, I'm sure, what may constitute unlawful rent increases, and what you might do about those. We'll also cover amenities, maintenance, and rent decreases. So those are things that come with your unit, and if they're taken away, you have a lack of maintenance, then there's a petition that you can file called a rent decrease petition. We'll explain that to you today. We also want you to know about the eviction protections afforded to tenants under the rent control law and additional protections related to the California COVID-19 Rent Relief Act. We'll also cover some things about exemptions. So there are some properties that are exempt from rent control due to owner occupancy, and properties can be withdrawn from rent control under the Ellis Act. So we'll explain the basics about how that works. And then finally, I'll give a demonstration of our new Civics rent control portal. And that is an online tool for property owners and tenants to be able to file petitions with us, various applications, including fee waiver applications for tenants. And I'll show you how you can get a Civics account and what you can file through that system. So because this, if we can move on, Micah. As this is a virtual presentation, I do want to point out that you can ask us questions. So on the right-hand side of your screen, you should see an icon so that you can click on it, and then you can type your question into the chat box. During the presentation, we'll stop at intervals and we'll address questions that are relevant to that section of the presentation. Many of you may have questions that are specific to your own situation. It may be that those are better addressed directly by speaking with one of the information coordinators or analysts here. So we'll probably focus today on the questions that are of general interest to everybody, but go ahead and ask your questions, and we'll direct you to where you can get information if we don't answer them here online. You also have a slider button if you want to change the size of the presentation relative to the video of a presenter. You just slide that slider in whatever direction you want. So let me just begin right with the rent control overview. Um, Rent control started in Santa Monica on April 10th of 1979. So we have been a part of the residential rental landscape here in Santa Monica for over 40 years. The rent control law was passed by the voters of Santa Monica, and it was set up, the rent control agency was set up slightly separately from the rest of the city. Rather than reporting to the city council, our agency reports to the rent control board. So the rent control board are five people from Santa Monica who are elected by the people to serve a 4-year term. They can renew that once for a second term. And currently we have 5 commissioners, although one recently resigned, and so the board will be soon appointing another commissioner to serve out the rest of the term. And then there are some commissioners, some seats that are open for this November's election. So there is the rent control board, and then underneath the board is the rent control agency or the department in City Hall. And we have an administrator, and we have 3 departments. Public Information Department is the one that Micah and I are part of, and again, we are the people who would meet you if you came to the counter or you call into rent control. And then we have a hearings department, and I'll explain what their role is, but they hear petitions for those rent decrease petitions that I was describing, or excess rent cases. And then we have a legal department, and what I want to point out there is that our legal department represents the rent control board, and they provide advice to the board and conduct litigation on behalf of the board, and they do not provide legal services to tenants. We can give you references for legal services if that's what you need, but we don't provide any direct legal services here at Rent Control for tenants. All right, we can move on. So the first question is which units in Santa Monica are subject to rent control? And the law applies to most residential rental units in the city constructed prior to April 10th of 1979. For units created after 1979, they can qualify as new construction and be exempt from the rent control law. You can see on the map there that there are rent control units across the city, but more concentrated in certain neighborhoods, and not so many single-family dwelling neighborhoods. So you see that there are some exceptions to the rent control law, and that's most single-family homes. And many condominium units. And we'll talk about how that works. Sometimes a condominium unit might have some of the protections of rent control, but not actual control over the rent. And then another category of exempt properties are those that are 2 or 3 unit properties that are owner occupied. Those owners have to apply for an exemption with us, and we annually certify to make sure that they continue to qualify for that exemption. If ever you wonder whether or not your unit is subject to rent control, you can call us, and I'll give you contact information later on. But we also have some tools that you could use to check your unit to see if it's subject to rent control. If you get our newsletter, then that's a good indication. And many of you signed up for the seminar probably because you received our newsletter. The tool that I was mentioning is a look up a rent feature on our on our website. We'll show you that a bit later, but you can enter an address, and if it returns rents or information for that property, then you can pretty much be assured that your unit is subject to rent control. but we can always confirm with you if you call us that you are and what your maximum allowable rent is. So we can give you custom information if you call us. All right, so let's go on to what the rent control law is all about. So there really, I consider there to be kind of four legs to a chair of rent control, and each one is important. The first is controlling all rent increases during a tenancy. So rent control limits how much the rents can go up from year to year. In most cases, owners are free to set a new rent with a new tenant, but then rent control limits the increases to that going forward. We also have remedies that are provided for situations where excess rent is charged, or if there is maintenance issues, or if amenities are taken away from a tenant. It's important to have these administrative remedies in order to be able to enforce the maximum lawful rent part, the rent that you pay. Another important part of the rent control law are eviction protections, and the reasons for which you could be evicted from your unit are very limited. Most of the reasons have to do with things that you may do wrong, and will like violate your lease or things like that. And we'll talk about those eviction protections later. But there are some jurisdictions with rent control that don't have eviction protections, and so they're not. Those laws aren't as strong as ours because if an owner doesn't like the tenant or wants to get more money for the unit, they would be able to evict the tenant. Here in Santa Monica, that's not the case at all. If you are renting and you basically are abiding by the terms of your rental agreement and paying your rent, then you shouldn't worry about eviction. There are, however, some reasons for eviction that are not related to the tenant's activity. So they are no fault reasons, and the owner, for example, may want to move into a unit on the property. There are limitations about which unit the owner can choose, and tenants would have to be paid relocation fee and some other things. So there are a few reasons for which you could be evicted that's really no fault of your own, and we'll explain what those are. But for most people, I know that you have protections against eviction. The owner can't just give you a notice and tell you that you need to leave. And then the fourth leg of the chair is protection against the removal of rent-controlled units. So when rent control started in 1979, part of the law, the intent of the law, was to make sure that residential rental units remain part of the fabric of the city, and that owners can't convert the use of existing apartment buildings into condominiums or something like that. So we limit the reasons for which a rent-controlled unit could be removed, and it's very limited circumstances, and we'll explain what those are. All right, going on to what our focus will not be today. So there are many things in the landlord-tenant relationship that are not covered specifically by the rent control law. Some things are covered by state law, some things are covered by the municipal code, and there are even some things that are covered by federal law. Some of the common topics that come up are those on the screen there that we won't be handling today. So the first is the return of the security deposit. Rent control does limit the amount of the security deposit that can be collected at the start of the tenancy, but the return of the deposit is all governed by California law. You'll see in the bottom left column there's a reference there to California Tenants, a guide to residential tenants, landlords' rights and responsibilities. That's a publication that you can view on our website. It's under the more information tab and then information by subject. And we have a link there to this publication, and it's very useful. There are probably about 10 pages in there just on the return of the security deposit, what's allowed and what's not allowed. Another subject we won't cover is the right of the landlord to enter a tenant unit. State law does limit when an owner can enter the unit, and it's generally for necessary and agreed upon repairs. And usually they must give, a notice to you, advance notice that they're going to be entering. But this specific issue is not part of the rent control law. And so if you have questions about the landlord entering, we would have to direct you to the California Department of Consumer Affairs. Eviction procedures are not going to be covered today either. We will tell you what the reasons for eviction are and the limitations on those, but the actual process of an eviction we will not go into. Evictions do happen in court, so any tenant who gets an eviction notice should immediately get legal representation and follow the advice of your attorney. You have to take eviction notices seriously. So if you get something, be sure to get in touch with one of the legal service agencies, like the Los Angeles Legal Los Angeles Legal Foundation. So also not covered today is noticing. So owners may need to notice of an increase in the rent, and the specific way that is presented to the tenant or to you is not covered by us today. So again, if you check that California Tenants Guidebook, it's really helpful, and it's written in language that really anybody can understand, and there are citations to the Civil Code if you want to look at the actual laws related to these issues. Another set of things we aren't going to cover are things that are in the municipal code, like tenant harassment. And just to be clear, that's not something that rent control deals with, but it is something that the Santa Monica City Attorney's Office deals with. And you can contact the Public Rights Division of the City Attorney's Office if you want to make a harassment claim. The threshold is really more, is the owner trying to get you to move, rather than are they just sort of unpleasant. But you can certainly discuss your issues with the City Attorney's Office if you have any. The city also provides permanent and temporary relocation in certain circumstances. Permanent relocation when you need to leave the unit because you're being evicted typically through no fault of your own. And for temporary relocation, if the Code Enforcement Division of the city orders that your unit is temporarily uninhabitable, then the owner needs to pay you a certain dollar amount every day that you're out, or make some kind of accommodation for you elsewhere, and then you have the right to return to your unit. So it's a temporary relocation just because they need to work on your unit. In case there's also building code violations. So if there are serious maintenance issues on a property, there is another division of the city called Code Enforcement, and you can direct your concerns to Code Enforcement. Unlike rent control, we control the rent. So our remedies are always relative to the rent that you pay. Like if there's a maintenance issue, we could possibly reduce your rent going through a process. A code enforcement can look at a condition, and if they can order an owner to do a certain repair. So we work closely with them, and if you call us and you have an issue that might be better addressed by code enforcement, then we'll transfer you to them. Short-term rentals, that's another thing that's happening in the city. There are laws against that. There really shouldn't be any short-term rentals. Tenancies are now supposed to be for at least 1 year. And newer tenants are supposed to provide documentation to the landlord that the unit that they're living in is their primary residence. We do want the residential housing in the city to be used to house residents and not for short-term hotel uses or vacation stays, that sort of thing. And then finally, we won't be talking about the smoke-free residential ordinance. A lot of times there are conflicts between tenants regarding smoking on the property. That's not a rent control law, but it is addressed by the municipal code. And if you have questions about that, you could visit the city attorney's website, and there's a page about the smoking ordinance. On that note, I'll also just mention that the rent control law doesn't address tenant-to-tenant conflicts. Mostly, we're talking about possible conflicts between the tenant and the landlord, and the rights and the responsibilities of both parties, but under the rent control law. So if you are having a conflict with another tenant, fortunately, we don't have a solution for you, but getting with patient communications is a good start. Okay, so now getting into what rent control is really about. So that what is the lawful rent that you can be charged? So the lawful rent is composed of as many as 3 things. First is what's called the maximum allowable rent. And this is the rent that the rent control agency tracks. And it's the rent that we report to you on the newsletter that you get for your unit. It is essentially the base rent for a unit, and we'll talk about how those base rents are set, or so the first rent, plus any allowed general adjustments through the year or over the course of years. So each year there's a general adjustment that can increase the rent, and the maximum allowable rent is updated every year based on what that general adjustment amount is. So we take the base and then we add applicable general adjustments. In some cases, a tenant might have to pay a registration fee pass-through. So rent control charges the owners of rent-controlled property a fee each year, and that funds the operation of the rent control agency. Because I said in the beginning, we are set up separate from the rest of the city. We don't share any of the tax revenues or other income sources that the city has in its general fund. We are independently funded by the registration fee that owners pay to us. That registration fee is due August 1st of each year. And if the owner pays that on time, then they would be entitled to pass half of that fee through to you as a tenant as a monthly surcharge. And we'll talk more about this in later slides. So that's something that might be in addition to the maximum allowable rent that you pay. And then in some cases, tenants can be asked to pay a share of the owner's property taxes. This only applies to tenants who moved in before March 1st of 2018 and on properties that have not been sold and reassessed since then. The Rent Control Board was concerned about the amount of the pass-throughs that were being, of these surcharges that were being passed through to tenants. especially because in some cases these surcharges are relative to the assessed value of the property, and so as properties sell, sometimes the taxes go up significantly, and if it were passed through to the tenant, that could mean a significant increase to the rent, the maximum lawful rent that they pay. So the board limited these surcharges for all tenancies after March 1st of 2018. We'll talk more about what those surcharges are later also. So those three components make up the maximum lawful rent. Okay, we can go on. So I talked about the base rent and the maximum allowable rent, which we abbreviate as the MAR. So we're always talking about the MAR if you hear that. And the base rent really depends on when a tenancy began. So for tenancies that began before January 1st of 1999, the base rent is the rent for the unit in effect on April 10th of 1978 in most cases. And that was 1 year before rent control started. So it was considered a free and open market, and we just had the owners report to us what were you charging for that unit 1 year before rent control started. And then we control the increases to that base rent going forward. So those are the increases that are approved by the Rent Control Board or otherwise allowed by the rent control law. For tenants who moved in after January 1st of 1999, and that's most tenants, about 75% of the tenants moved in after that date. So the base rent for those tenancies is the rent that the tenant paid when they first moved in. The owners are required to register that amount with us, and then we track the general adjustments or the annual increases year to year after that, and we report those as the maximum allowable rent. So the big difference is, did you move in before 1999 or after 1990? That establishes your base rent. With the pre-99 tenancies, that rent was always based on 1978. With the post-1199 tenancies, it's whatever the tenant paid when they moved in, and with each new tenancy, owners are in most cases free to set a new base rent for the unit. And they do have to register with that with us. So, all right, if we could just go on. So I mentioned there are some ways that you can check the MAR for your unit. On the upper right, you see the circle that should appear on the newsletter that you receive. That should be current based on the information that the owners have provided to us on the registration of the tenancies. If you see something that doesn't look right and consider the actual rent you pay may include the registration fee and possibly some surcharges. But if that doesn't look right to you, please contact our office. It may be that the tenancy wasn't registered. One of the ways you can check that is on our website, which is santamonica.gov/rent control. So the city has a new website URL, and it's santamonica.gov that started in January this year, and then /rent control. That'll take you to our homepage, and then you'll probably want to click the more information tab, and that takes you to another page where you can find a feature that's called Look Up a Rent, and it's circled there on the lower left. So you click on that, and it opens up a screen that's to the right of that there, and you can just enter the address of the property where you're living, and it will return what the registered rents are for that property. We have also included the tenancy start date if the tenancy began after January 1st of 1999, and you can check that for your unit and see if what's registered is correct. It may be that the owner hasn't re-registered the tenancy. They are required to. So if you contact us, we'll get in touch with the property owner and remind them of their registration requirement. Okay. So I mentioned the rent control registration fee. This is, the second part of the maximum lawful rent pay. As I explained, it's a fee that owners have to pay to us every year. Currently, the amount of that fee is $198 per unit per year. And when you, as I said, if they pay that by August 1st of each year, then they can pass that through to you, pass half of it through to you as a monthly charge. Currently, that charge is $8.25, which is basically $198 divided in half and then divided by 12 months. The Rent Control Board determines its budget each June, and next month they will be having a meeting and deciding what the registration fee will be for the coming year. That our fiscal year begins on July 1st. So we'll talk about the notice that you might receive for a rent increase later this year, but keep in mind that it may be that the registration fee is different from $8.25, which it is currently. But we'll be sending a mailing to you, to all tenants, at the end of June, and we'll explain exactly what the general adjustment is going to be this year. We're going to talk more about how the rent increases and what that general adjustment is. But part of the form that owners give you to raise your rent may include this registration fee, and it may be different from $8.25. Okay. And then the last part are these allowable surcharges. Again, these are only for tenancies that began before March 1st, 2018. The owner bases these on the property tax bill, and when they give you notice of a rent increase, like in the fall, if they are charging any surcharges, they're required to provide a copy of the property tax bill along with the notice that you're going to receive. There is one item that is constant for all properties, and if that's the only item that they're charging you, then they do not have to provide the property tax bill. Again, all of this will be explained in the newsletter and the mailing that you'll receive in late June. But these surcharges also have a maximum. So it's for those who can pass through surcharges, the amount that they can pass through is limited to 4% of the maximum allowable rent, that MAR portion of your rent, or $35, whichever is less. So you want to check the notice that you'll get. Again, we'll show you one of those later, and make sure that the amount of the surcharges being passed through to you is not more than 4% of your MAR or $35. And again, they can't do that if the property has been recently sold and reassessed, because those taxes go up, and that cuts off their ability to pass through the surcharges. All right. This is a sample of the property tax bill, and it may be a little bit hard to read, but there are certain line items on the property tax bill that we've put in bold. They won't be in bold on the tax bill that the owner provides to you if they're passing through surcharges, but these are identified. There are 5 line items on the property tax bill that might be part of what you pay. So those are limited to a community college, tax, the Unified Schools tax, the Santa Monica Stormwater Fee, Santa Monica Malibu Municipal, or Santa Monica Malibu Unified School District Measure R fee, and a Santa Monica Clean Beach tax. So the owner, if they send this to you, can redact or black out those other fees, but they do need to show you that on their tax bill, these are the specific amounts, and we'll show you what they do with these amounts to arrive at the surcharge that can be passed through to you. But you should always be getting a property tax bill if the owner is trying to pass through surcharges to you. And they pass the taxes through for the prior year. So this year, the tax bill that they should be using would be the 2021 tax bill. Right, so this is slightly out of date, but we could go on to the next slide. So we talked about the rent control starts with a base rent, which is different for the tenants who moved in before 1999 and the ones who moved in after. So once we have this base rent, then the rent control law provides that there will be annual adjustments or general adjustments to those base rents. The idea behind this is that owners' costs go up over time, and a part of the rent control law is to ensure that owners also make a fair return, that they continue to make a fair return, but no more than a fair return. So the purpose of the general adjustment is to essentially provide owners a little more money each year so that they continue to make a fair return. So how do we decide what that amount is? In the past, we used to look at owners' actual costs, and we would do a study every year and determine, what percentage increase would be appropriate. As we looked at those, we saw that they basically tracked the inflation rate, but like 75% of the inflation rate. So in 2012, I believe, we put before the voters approved a way of calculating the general adjustment that is very objective. And it is based on 75% of the change in the consumer price index reported for LA, the LA area, each March. The consumer price index is a measure of inflation. So this is reported by the Bureau of Labor Statistics. So the number is published, and we calculate what 75% of that is. This year, the CPI for March was 8.5%. When you calculate 75% of that, you get 6.4%, rounded to the nearest tenth. And 6.4% would be the general adjustment this year. However, there is a provision in the rent control law, also approved by the voters, that says if 75% of the CPI is more than 6%, then we're capped at 6%. Since the CPI, 75% of the CPI this year was 6.4%, the GA this year, the general adjustment, is 6%. And this is set in the law, and the formula is set in the law, and really only the voters of Santa Monica can change that law. So although inflation is very high this year, the 6% general adjustment is unavoidable. It is what is in the law. I will point out that this is the general adjustment to the MARS. So we take your rent and we add the 6% if it's eligible for this year's general adjustment. But it doesn't mean that the owner necessarily has to charge you a 6% increase this year. It's up to the owner to decide whether or not to increase your rent. It's just that rent control says you cannot raise it more than 6% this year. Also, another provision of the rent control law is that there might be a cap on the amount of the increase. So what is in the discretion of the rent control board is to decide whether or not to impose this cap, this maximum dollar amount that the rent could be increased this year. And that is set also by a formula that was approved by the voters. And when we do that calculation, we arrive at what would be a $140 maximum dollar increase this year, but that's per month. That would apply to rents generally on the higher side, so specifically $2,325 and above. So those, the general adjustment on those higher rents would be $140. This is not yet, the board has not yet decided whether or not to impose a cap on the general adjustment. They will have a public hearing on June 9th to decide whether or not to apply this formula and cap the rents for, cap the increases for rents of $2,325 and above to $140. So the units above that would not be getting an actual 6% increase. It would be something less than 6% of the rent. If you are interested in commenting to the Rent Control Board about whether or not they should impose a cap, you can contact them through us if you send an email to rentcontrol@santamonica.gov, or you could go to you could speak directly at the meeting. We'll be posting the agenda on our website 1 week before June 9th, and you can go there and request to speak to the board on this issue. Again, there will be a public hearing June 9th to decide whether or not to cap the rent increases at $140. In all cases, if the owner is going to increase the rent, they are required to give a written notice, and the notice has to have specific information on it. We do provide a template for the owners to use. Many of them do use that. They're not required to use the form that we provide. I will show that to you later in the presentation, what it looks like. But they do have to give written notice, and typically that is at least 30 days in advance of the rent increase. The rent increase takes effect September 1st, so they might be giving you a notice sometime on or before August 1st of this year about the rent increase. And then finally, the rent control law doesn't require that an owner implement a general adjustment each year. Even though they do not implement the general adjustment, or they don't give you a notice to increase your rent, the maximum allowable rent under rent control is increased by the general adjustment, whether or not the owner takes it. This means that it's possible for an owner to defer some general adjustments for a year or two or more, and then later give a notice to the tenant and bring the rent up to what is the current maximum allowable rent, which may be inclusive of several previous years' general adjustment. So in some cases, if the owner hasn't given a notice that is, keeps the tenant current with the maximum allowable rent, the tenant might see an increase that is surprisingly large, or in this year's case, maybe even more than 6% if the owners never increased your rent before. It's possible they can bank these increases and give you a notice that will take you up to your maximum allowable rent. You can always check that maximum allowable rent, as I've said, on our website or by calling us, so you know that what they're attempting to charge is correct. But for the newest tenants, there won't be a general adjustment this year. So the rent control law provides that if the owner is going to take a general adjustment this year on September 1st, then the tenancy has to have been in effect for at least 1 year. So if your tenancy began after September 1st of 2021, then you're not eligible for this year's general adjustment. The owner will need to wait until September of 2023 to be able to increase your rent. If your tenancy began before September 1st of last year, then in most cases it would be eligible for this year's rent increase. All right. So this is a sample, maybe a little hard to read. Again, you can use your slider to make that part of the presentation larger. But this is a sample notice of change in terms of tenancy. So this is typically the form that owners use to increase the rents each year. Your name and address would be found at the top, and then they would enter what the old MAR was, or so the MAR before this year's increase. And then on line 2, they tell you what the actual dollar amount is this year. Again, it would be 6% of line 1, or $140. And then they'll add those up and provide that on line 3. And then on line 4, they might be adding the rent control registration fee pass-through, which might be $8.25, or it might be slightly more this year. And then if your tenancy began before March 1st of 2018, they might be passing through some surcharges in section C there on the form. And then they give you, they should be attaching the property tax bill, and then giving you the total rent to pay. And that rent is what you would pay beginning September 1st of this year. If they don't get the notice to you 30 days in advance, then you should contact the landlord and tell them that you're entitled to a 30-day notice, and they should make that effective 30 days from the date that they gave you that notice. Typically, they'll make it effective the next month if they didn't get it to you. If they don't get the notice to you by August, they can't take it by September, but they could also take it anytime after September. So it's possible that the owners don't get around to giving you a notice until maybe December of this year, and then it would be effective 30 days after that. Okay, and going to the next part. So I talked about the registration fee pass-through, that $8.25. Rent control does offer a waiver of that fee for very low-income tenants. You can apply for this if you are a low-income senior or a low-income disabled tenant. I will show you how to do that at the end of the presentation. And if it's approved, we don't charge the owner a registration fee for your unit, and they have nothing then to pass through to you. So that second part of the maximum lawful rent would be erased. There's no registration fee pass through if you have a waiver. There's also one of the taxes that can be passed through to tenants who moved in before March 1st of 18 is the Clean Beaches and Ocean Parcel Tax surcharge waiver. Low-income tenants can apply for a waiver of this tax also, and that application is on our website. If you go to santamonica.gov/rent control, go to more information, and then you'll see the waivers of the registration fee applications. So you can send in one of those to us. So there are possibly some waivers of fees and some limitation to taxes. So, all right, we've reached our first question slide. So let me just look at what's been posted so far. Someone's asking if you can get a recording of the seminar and watch it later. I'm sorry I didn't announce that in the beginning. Yes, we are recording this, and we will post this on our website. And you can just go to it. It's on our seminars page. Again, rent control, santamonica.gov/rent control. Go to more information, and then you'll see a seminars tab, and you'll find it there. One person is saying that their issues are really those issues that are covered by state law and municipal code. We don't cover those. They're wondering if there's another seminar that would cover those. Some of the things that are covered by the municipal code are in the seminar that we do with code enforcement in the fall, the maintenance seminar. And then some of the other things related to tenants' rights, like the anti-harassment ordinance, those we will cover in the landlord-tenant forum that's typically held in December of each year. We have recordings of those presentations also on our seminars page. So if you want to go back and look at those, you're welcome to. If you have questions that we're not covering today, you can contact our office, and one of the information coordinators or analysts will direct you to the right resource. So you can call us at 310-458-8751 or send an email to rentcontrol@santamonica.gov. All right, so we have a question about what is low income. So the low income amounts, and I assume this is for the rent control registration fee waiver for low income seniors or disabled tenants. The amount actually depends on how many people are in the household. So when you attempt to file one of these applications, we put up what the actual amounts are. We'll take a look at those later in the seminar, what the actual amounts are, because I'll show you how you can file those fee waiver applications online through our new Civics portal. So someone is asking where they might go to find low-cost legal advice for a tenant. The Legal Aid Foundation of Los Angeles does have a Santa Monica office. We have contact information for them on our website. Mike, I may have memorized the number. I can look for it for you in a second. I'll put it in the chat for you. So you'll have that number to call if you need legal advice.
Yeah, Dan, they can be reached at 310-899-6200. 310-899-6200.
Great. Thanks, Mike. I figured you'd have that. Sometimes you have to leave a message for them, but they will call you back. So, okay, somebody's asking, when will the MAR be updated online? Sorry, I forgot to mention this. So currently our maximum allowable, our lookup a rent feature has been paused at the end of January. And that is because we have transitioned to a new information system, and we are just trying to work out the details of how to do daily updates to that so it's current. And yeah, somebody knows this, it has to do with the new website. So yeah, we are having an issue with that. It's a known issue. We're trying to resolve that as soon as possible. If you can always contact our office in the meantime, and we'll tell you what we have as the maximum allowable rent and on which tenancy date that's based, what base rent that has. someone is pointing out that they happen to know that the property owner where they live has not paid their property taxes. And of course, they cannot pass through what they're not paying. So, I think if an owner attempts to pass those surcharges through to you and you're aware that they have not paid their taxes, I suggest you contact us with the notice that you receive, and we can get in touch with the owner and let them know that that would be considered excess rent if they attempted to collect that amount from the tenant. We generally advise tenants to pay the amount that they have been noticed, just to avoid the owner claiming non-payment of rent and possibly trying to seek an eviction in court. But there are remedies through us if you do overpay, and we can certainly help you with those. All right, so I will turn this over to Micah now for the next part of the presentation. Yeah, Micah, that's the end of the questions.
Great. So we're going to move on. We're going to start talking about those rent increases that may be unlawful. Charges for additional amenities. So additional amenities can be added by mutual agreement only, and there are specific requirements that differ for pre-99 and post-99 tenancies. Charging for additional amenities without a proper agreement may constitute a collection of excess rent. One of the things like Dan was talking about with the surcharges if they're improperly charged. So for the tenants that moved in before January 1st of 1999, the owner and the tenant may negotiate what's called a separate agreement for a monthly rental of amenities that are not base amenities to the unit. Separate agreements must be negotiated separately, as the name implies, must contain terms comparable to those of similar arrangements in the unregulated market. So, the landlord and the tenant both need to think that the amount charged for the addition of a pet or the addition of parking or anything else is comparable to something that could be negotiated on an open market. Continued existence of this agreement is not a condition of tenancy. So if the landlord had to terminate the agreement or the tenant had to, they decided that they didn't want the separate agreement anymore, that is not a reason for the landlord to end the tenancy. And then breach of that agreement is also not grounds for eviction. So if something falls through with that, that's not a reason that your landlord could evict you. Additional amenities for tenants that moved in on or after January 1st of 1999 are limited only to parking or a garage, storage, and the right to have a pet. So just those three things. Again, they must be the result of an arm's length negotiation with no pressure on the tenant to accept the amenity, and the amount paid for the amenity must be comparable to a lawful arrangement in the unregulated market. Owners must register the initial amount charged for the amenity with the board. So we have a special registration form for that. And then that amount gets rolled into your MAR and would then be subject to the general adjustment each year. So the new total now becomes your MAR, and that amount gets increased by the general adjustment each year. There is no provision in the rent control law that allows owners to charge additional fees simply for adding an additional occupant to the unit. A tenant's right to sublet their unit or have guests is usually controlled by the terms of their rental agreement. Violations of the rental agreement could be grounds for eviction. The municipal code prohibits eviction based on occupants being added if due to marriage, domestic partner, if it's properly registered, birth or adoption, or change of legal custody of a child. If the tenant sublets and no longer permanently resides in the unit, the owner may be entitled to a one-time rent increase. There's a petition process for the landlord to go through if the named tenant, the primary tenant on the lease, no longer lives there. Utility costs are something that a landlord cannot charge you additional or fluctuating amounts for. If a unit is separately metered, the tenant can pay the utility company directly, and the tenant can be required to pay those full costs. But if a unit is master metered, so that's just one meter for the whole property, and the lease requires the tenant to pay a share of the monthly utility bill, the owner must specify the exact dollar amount at the start of the tenancy. So that amount needs to be registered in the base rent, in the MAR of that unit, and it can't fluctuate. So if water usage suddenly goes up or down, the tenant can't be charged more or less because of that on those master metered properties. When there are tenants not in occupancy, so this is going back to that tenant who moved out and then sublet their apartment, or if they're just not using the unit as their primary residence anymore. Because rent-controlled units are supposed to be used as the primary residence and address of usual return for tenants, if an owner believes that the tenant is no longer permanently residing in the unit, they may file a petition with the board to raise the rent to a comparable market rate rental. And there is a formula that exists in the code that helps a hearing officer determine just how much that increase would be if the landlord is successful in their petition. A decision in favor of the owner is not a reason for eviction. So it's only a reason to raise the rent on that unit to a closer to market rate rent. It's not something that in and of itself can or would terminate that tenancy. So if the landlord is charging more than they should, we have a petition process in our office called a complaint for excess rent. It may be filed by tenants or subtenants who believe they have been or are being charged amounts that exceed what is allowed by the rent control law. The rent control hearing examiner finds that the excess rent has been collected. A tenant will be authorized to withhold rent until the amount of excess rent has been recovered. The Rent Control Board can only issue awards for excess rent collected in the previous 36 months. So it is important that you don't sit on it too long. If you believe that you are paying excess rent, you should contact us quickly and not let it go on for years. Interest and penalties can also be included in the amount of the award. So again, it's not that the landlord would write a check back to the tenant for the amount that they've overcharged them. The tenant would be authorized by a decision of the hearing examiner to withhold a certain amount of rent over time until the excess rent has been recovered by the tenant. Any questions on this section here? Dan, do you see any?
So far, we don't have any, but if somebody does have a question, please type it into the chat. I'll add to what Micah said that we do have a mediation service. I don't know if that's coming up, but most of our excess rent cases can be resolved in mediation. So 92% of them were last year. So it's a way of, resolving the issue quickly rather than going into a hearing with us. But in some cases, the owners will realize that they made a mistake and then in fact do just cut a check to the tenant. And we make sure that whatever terms were agreed to in mediation are satisfied. All right, I'm not seeing any questions on this section, so if you want to go on.
Okay, yeah, I'll go ahead and move on. If your questions do come up or come to you later, please go ahead and enter them into the chat, and in a few slides we'll have another opportunity to answer some more questions. So we'll talk now about maintenance, amenities, and rent decreases. Owners are required to maintain the property and the property's base amenities and housing services. In rent control, the goal is that the tenant is still getting the full value for their rent dollar. And part of what your value of your rent dollar is made up of are the amenities and housing services that exist. These are the things that were provided on the base rent date, and that could be for a pre-99 tenant, that base rent date is what was provided to the unit April 10th of 1978 when it first was registered, the basis of what was registered for rent control, or for a tenant that moved in after 99 or on January 1st of 99 or later, the base amenities and housing services are based on what you had when you moved in, so what was included in your lease. Examples typically include parking, appliances, the right to have roommates. So the base housing service, if you moved in with 3 people, that would be your base housing service and the number of roommates that should be in the unit. But it also includes common area housing services and amenities such as gardening services, laundry, recreation rooms, pools, anything like that that might be included. And then the owner must maintain the condition of your unit. Maintenance would include things like water leaks, worn paint, flooring, carpeting, broken windows, doors, screens. If you're dealing with an insect or animal infestation, heat must be maintained, plumbing, smoke alarms, counters, grout, caulking, things like that all need to be maintained. This is partly the landlord having the right and responsibility to maintain their investment, and then part of it is making sure that you're getting the full value for your rent dollar. So the remedy that we have, since our authority is to control the rent, if the landlord is not giving you your full value for the rent dollar because of neglect of any of these areas or removal of any of these items, is called a rent decrease petition. Tenants can petition for a rent decrease when an owner reduces or removes base amenities, housing services, or fails to make those necessary repairs. Decreases are calculated from the time the petition is filed, and rent decreases would remain in effect until repairs are made or the amenities or the housing services are restored. Often we get the comment that, I don't want my rent decreased, I want new carpet, or I don't want my rent decreased, I want my parking back, or I don't want my rent decreased, whatever the item may be. Our authority is to control that rent, and the intent of the rent decrease is to provide motivation to the landlord to make the repairs that they should make to provide you the services that they agreed to provide when you first moved in, or your landlord at the time agreed to when you first moved in. Excuse me. And if they're not providing that service at that same level, then your rent would remain reduced until they make those repairs or return the amenities. Excuse me. We have a different kind of rent decrease that is related to construction. So these may be granted when a unit becomes uninhabitable due to construction, or it substantially reduces housing services, or when the construction interferes with the tenant's ability to occupy the unit as a residence. The no decrease would be authorized for unavoidable construction impacts caused by necessary repairs or maintenance, unless the construction is carried out in an unreasonable manner or construction takes an unreasonably long time to complete. Regulation 4400 sets a decrease range for many possible issues. The decrease is calculated from back to when the impacts were first felt by the tenant, so when those problems arose. So this is different from the maintenance-related issues, the maintenance-related rent decrease in that way as well. Construction-related impacts go back to when the construction began. These also must be filed with our office before construction completes. The maintenance one, you have a little bit more flexibility, but you also don't have the ability for it to go back in time retroactively. One thing that's important to note, there's a lot of construction right now for seismic retrofits. That is work that has been mandated by the city, and unless that seismic retrofitting work is being done in an unreasonable manner or taking an unreasonably long time to complete, we're not able to award a rent decrease for that kind of mandatory work. And then, as Dan mentioned earlier, there are mediation services available for this and all of our petitions, and they have been quite successful. A lot of times, if something is just not being taken care of, there's not enough dust mitigation or noise mitigation. Mediation can be really helpful to step in and figure out what's needed to make that unit more habitable and have the construction be less impactful to tenants. All right, any questions on decreases or anything else we've covered to this point?
Yes, looks like we have a couple of questions. One is worn paint, question mark. So as in a previous rent control seminar, we were told the owner has no obligation to paint. If the tenant paints without the owner's permission, is it grounds for eviction? There's a couple of questions embedded in that. Do you want to take that, Micah? So,
Sure. I mean, so my understanding has always been that the paint on the wall is part of the value that you're getting for your rent dollar. It is an item that is included in our standard notice as a commonly raised issue, and there is a dollar amount range set out in section 4200 4200D that gives a typical range for how much deteriorated paint could reduce your rent. So the landlord does have that responsibility to maintain that normal wear and tear. The other piece of the question, though, is true. If the lease specifically says that you will not paint and you paint without your landlord's permission, that could be a violation of the lease. So, the best course of action here would be to use the remedies that are available to you, provide written notice to your landlord requesting that they provide new paint because the paint is worn, and then if they don't set something up for you for repainting within 30 days, file that petition with our office. And is there anything else you'd add to that?
Well, no, I would just say that sometimes if there's a question over the condition, is it something that the owner really has to do, or is it just something that the tenant kind of wants? Is it has it gotten to the point where it would qualify for a rent decrease? The tenant you could go ahead and file a petition for rent decrease. We'll talk about the process, but you'd notify the owner of the issue. If the owner disputes it, then we might be able to work it out in mediation, or it might go to a hearing, and then a hearing officer here at Rent Control would decide whether or not the rent should be reduced because of the condition of the paint. But I don't think we ever said that the owner's no obligation to paint. Owners are required to maintain units in good condition. Otherwise, you do have this remedy through us. And for is it grounds for eviction? Yeah, it's true. If it's a lease violation, it might be, but typically you'd want to have a pretty serious violation of the lease before you got evicted. And if the owner did attempt to evict you, you want to get legal representation right away. So we have a question. Is there a time limit on applying for a rent decrease based on an owner removing an amenity that previously existed? That, Micah?
No. So if you had that previous amenity, even if it was years ago, you could still apply for that rent decrease petition. You could provide written notice to the landlord, and after 30 days, if they haven't restored that amenity, then you could file the petition with our office. Like I mentioned earlier, though, there's no retroactive award for the decrease. So if they did take that amenity away several years ago, the decrease would not go all the way back to that date. It would actually go back to the first time rent is due after the petition is filed with our office. So, if you didn't know that this remedy was available to you and something's been gone for a while, that doesn't mean that you shouldn't still attempt to provide notice to the landlord and see if this process can be helpful for you, either through mediation or a hearing.
Right. Action is better sooner than later, because you won't, see that your rent adjusted for that, the removal of that amenity, until you file. Okay, another question we have is, I just won a small claims case against my landlord. I took this action because of damage to my property during repairs. Is there anything I can do within the excess rent process to collect those fees, or do I need to go through the courts again? Um, I'll take this one because I want to point out the rent control law doesn't provide any remedy for damage to your personal property. So this person did, what seems to be the appropriate thing is to seek a remedy in court. But there is no way through the excess rent procedure to collect your fees related to the court, and so you should take whatever action would be appropriate. There is no remedy here for that. The landlord didn't collect that as rent, so there's no remedy. Any other questions? Go ahead and post them. Otherwise, we will move on. All right, go ahead, Micah.
All right, so talking about one more of the legs of the rent control law that keeps it stable, the eviction protections. So landlords must have what is called a just cause for eviction, and they're limited. There are 7 fault reasons and 3 no fault reasons that would allow a landlord to evict a tenant, to terminate that tenancy. So fault reasons would include things like non-payment of rent, violating an important condition of the rental agreement, causing substantial damage to the property or substantial nuisance, refusing lawful access to the rental unit. So that does require, that's something that falls under state law, but because, if the tenant is denying that lawful access and the landlord is following state law, that could be a potential just cause for eviction. There are also no fault evictions where the tenant didn't do anything wrong, but the landlord is still able to evict and recover their property. Those include owner-occupied evictions, withdraw the property from the rental housing business. So that's something called the Ellis Act, which is a state law. They can be granted a removal permit if the property is not habitable and it is not economically viable for them to make it habitable. For most no-fault evictions, there are specific requirements that must be met, including requirements in the municipal code for the payment of a relocation fee for displaced tenants. In some cases, with these eviction protections, particularly in fault reasons where the tenant is at fault, a written opportunity to correct is required. That was part of Measure RR that passed some years ago. And one important thing to remember is that the end of a lease is not just cause for eviction. So some leases still have language in it that says, that the landlord may give the tenant 60 days notice to vacate after the lease is up. That is not true in Santa Monica there for a rent control unit. They are not able to just give you notice and say, you need to move out. The COVID-19 Rent Relief Act is still providing some protection for some tenants that are qualifying for it, as long as they submitted their application before March 31st of this year. If they still had months available and they're still waiting on a final decision from that program, state law can provide eviction protections against a landlord filing what's called an unlawful detainer for the non-payment of rent for those months that the tenant is eligible. These state level protections are in place until June 30th to allow the program to have more time to process these applications. And then landlords or tenants, if you're interested in the status of your application, you should be able to call the rent relief number, and their call center number is 833-430-3600. 2122, and their website is housing.ca.gov. This is that Housing is Key program that many people have heard about over the course of the pandemic. So in addition to the state protections, which were specifically for protecting tenants for non-payment of rent, there have been local and county eviction moratoria in place for reasons other than non-payment of rent. The Santa Monica emergency order is currently on its 42nd supplemental order. This one is valid through June 30th, unless extended. Residential tenants are protected from the following kinds of evictions: no fault evictions, including owner occupancy, refusing entry into a unit with limited health and safety exceptions, having unauthorized occupants or pets in their unit with limited health and safety exceptions, nuisance. Certain behaviors or conditions that would normally be grounds for eviction are protected at this time. Again, limited health and safety exceptions for that. And then Ellis evictions cannot take place right now. There's a 60-day extension after the end of the emergency order on the Ellis eviction. Within LA County, there are a couple of phases of their eviction moratoria that are still in place, including the phase 1 that goes through the end of this month, and then phase 2, when the non-payment of rent protections end for the state, or scheduled to end for the state. Los Angeles County has a program that is set to launch, but that only protects households that were at or below 80% of the area median income, and only due to COVID-19 financial hardship. There is a self-certification where tenants that are in that income range are able to declare that they are still facing hardship, and this is for rent that hardship and rent that is missed after July 1 of 2022. For more information on Los Angeles County's eviction moratoria, their website is dcba.lacounty.gov/no-evictions, the Department of Consumer and Business Affairs. So dcba.lacounty.gov/no-evictions. And more information is available on the Santa Monica website, which is santamonica.gov/coronavirus. santamonica.gov/coronavirus. If the eviction moratoria were not currently in place, eviction for owner occupancy would be one of those just causes for eviction that is not the fault of the tenant. In order to qualify for this type of eviction, the owner must be a natural person with 50% or greater ownership interest in the property. They can evict to have a close relative move in to the property, but that owner must own it as a natural person. It can't be an LLC or some kind of company, and there are a limited number of trusts that qualify for this type of ownership. It is limited to one unit on the property, and it cannot be used if an owner already has possession of a unit on the property. So an owner or one of those close family members, and the relationships are laid out in our code. There are specific restrictions on the selection of the unit, and permanent relocation must be paid to the tenant if they are evicted in that way. If you receive an eviction notice for owner occupancy, please call us. We need to be aware of it. We need to talk through the next steps. There are certain things that we need to do to make sure that they're doing it correctly, and there are other agencies that we may need to connect you with as well. The Ellis Act is when a landlord decides to go completely out of the residential rental business. They just are completely going out of business for that building. It's a state law, and most tenancies are either terminated in 120 days or 1 year from when they file for this. Withdrawal may not be completed during a tenant's lease term. Individual condo units may not be withdrawn. So it has to be the whole building. It can't be just because a condo unit is separately sold. It cannot be drawn to the Ellis Act. City ordinances provide additional protection against no-fault eviction for educators and students during the school year. relocation benefits must be paid during the tenant. It must be paid to tenants being evicted. Displaced tenants who income qualify may be given priority for affordable housing options within the city. Property returns to rent control if it's re-rented, and displaced tenants may be able to return to the property if the owner re-rents within 10 years. If the owner re-rents within 5 years, the rent is restricted on that property. So another way that a tenant and a landlord may agree for a tenant to move out, this is not an eviction, but this is something called a buyout agreement. It's a voluntary agreement where a landlord and a tenant agree to a certain amount. Sometimes this is referred to as cash for keys, but they agree to a certain amount for a tenant to move out. If a tenant does accept a buyout agreement, they are not given priority on the affordable housing list because this is not an eviction. So that is also something for tenants to keep in mind when considering a buyout agreement. We have this information and more on our website about buyout agreements, but essentially it's important to know that landlords must give a tenant written notice of their rights. Those include the right to not enter into the buyout agreement, the right to consult with an attorney and or the rent control board before signing, the right to cancel the agreement at any time up to 30 days after signing. And one question that we get a lot that we can't really answer is, how much is it worth? How much should I agree to? What we can provide is the data that other people have used in the past or have agreed to in the past for their buyout agreements. So our most recent data from 2021 are the charts that are listed here, but we have data going back several years on our website. This is listed by the different areas of the city, as well as unit size, or what other people have deemed fair for buyout agreements. Are there any questions about evictions, buyout agreements, anything like that?
There aren't any that have been posted yet. I would like to add just a point to that buyout slide that if a tenant accepts a buyout, then they will not have priority for affordable housing, as if they were otherwise to qualify. If they are evicted for no fault reason, they would if they income qualify, but not if they accept a buyout offer. So tenants have to consider carefully whether or not they want to accept a buyout offer and know what the market rates are for other units in Santa Monica. Okay. Okay, this question is, if a landlord in the past has allowed a tenant a certain provision that was not addressed in the original lease, does that subsequently become in practice part of the lease? My past landlord allowed me to have a pet in the apartment. The apartment building has now been sold. Is the new owner required to let me have a pet again if I find one? Or do I have to apply for permission with the possibility that my rent might be raised as a result? Tackle that, Micah?
I'm gonna let you go ahead and
All right. Sure. So, first of all, a rental agreement can be something that's written, it can be oral, it can be implied, and a landlord's conduct over time might change the provisions of the rental agreement. For example, if your rental agreement said no pets, and the landlord kind of gave you oral permission to have a pet, or knew that you have a pet and brought over doggy treats and never said anything to you about it being a possible lease violation, then there is sort of an implied change to the terms of the tenancy, and it may be difficult for the landlord to seek an eviction for a lease violation for that issue. But the question for us is, it's like for example, if a pet is not part of the original rental agreement, what kind of evidence do we have that the landlord allowed some change to the terms of the agreement? It's not clear. The best practice would be, since it appears not to be part of your original terms, to talk with the new owner and possibly get it in writing whether or not you can have a pet. I think you can make the point that the prior owner did allow you to have a pet, and so you consider that there's been a change. It may be difficult, to convince the new owner, or maybe difficult to convince them that happened. Maybe they are aware of it. But the best thing would be to get written permission so that you're no longer in violation of your lease. If you moved in before January 1st of 1999, you could negotiate for a certain amount of rent with the owner for the pet, and that does not become part of your maximum allowable rent. If you moved in after January 1st of 1999, and you do come to some agreement with the landlord on the pet, then the landlord, if it's for an additional amount of rent, then the landlord does have to register that with us, and then it becomes part of your maximum allowable rent. But also that additional amenity becomes part of your tenancy. So that permission to have the pet would continue for the duration of your tenancy. If you no longer had a pet, then and you no longer want to pay that additional amount, it can be required by the owner because it's now part of the maximum allowable rent. But we could possibly have a mediation through our hearings department and maybe come up with an amicable solution to reduce the rent because you no longer have that pet. So I hope that answers the question. All right, I'm not seeing any other questions about this. I will have one question actually. One of the things that was mentioned for an Ellis withdrawal of a property is that the tenants might be evicted in 120 days or in 1 year. So Michael, what's the difference? Why would somebody be evicted after a year versus 120 days?
So in most cases, seniors and people with a permanent disability can request that their eviction date be postponed for a year. And then there are also, not quite a year, but there are restrictions for minors and educators that they don't get evicted in the middle of a school year. So that might extend it beyond that 120 days as well.
Right. And if anyone on the property qualifies for that 1 year date or extension, then everybody on the property qualifies for that. There's a state law that extends it for everybody, and there's just one withdrawal date 1 year later. All right, any other questions? Seeing any, so we can go on.
All right, I'm going to turn it back over to Dan so that he can talk about civics.
Great. So we are very excited here at Rent Control to be introducing this new online portal to interact with us. Rent Control, as we explained, has been around since 1979. And for most of our existence, we've had an internal database to track the rents and property ownership. But that system was developed in the 80s, and we've continued to put Band-Aids on it, and it has served us well. But time came for us to develop a new solution for our database. And we did that. We've been working on it for a couple of years, but we have now implemented it, and we have been using it here in the office and processing tenancy registration forms and updating ownership and processing fee waivers with it. But there's also a public-facing component, and we call that civics. And that is a way, either on the computer, or it would work on a cell phone or a tablet, that both owners and tenants can file various application forms with us, petitions, exemption applications, variety of things. Currently, we have about 15 different forms that are available, and 3 of those are forms that tenants would file with us. We are continuing to develop the other petitions that we're going to add to this system in the future, but right now we focused on those things that are filed most frequently. I'll show you what you'll be able to do. Most of the forms are really for property owners because they have to comply with various registration requirements for us and pay fees and things like that. So much of the current forms are generally for landlords, but there are some things that tenants can file. I've already mentioned the lookup a rent, which we're still working on. We also have a document portal. So Civics is part of what we've been calling Rent 2020. That includes some upgrades to lookup a rent and to our document portal. So we have a portal on our website where you can go in and type the address of any property, and you can see all of the scanned documents that we have for that property. You can sort them and download them. You can search by year, by document type, and the records go back to 2005. We do have some older records that will be moving into the system over time, but mostly it's what's almost been 20 years of documents are now available to you. You go to santamonica.gov/rent control, and then go to more information, and then you'll see the document portal there. One thing I might point out is currently, in our old system, the way that we did numeric streets like 10th Street, we entered it as 10. Actually, that's not a good. Well, 10 ST instead of 10th, the ordinal. In our new system, we have both of those street designations, and you need to currently search for them separately. Something that you'd search for with the 10th Street would return newer records, but we're working on integrating those two, so no matter which one you type in, you'll get all of the records. But currently, you might need to do 2 separate searches. But that's a good tool if you want to check anything about your property and see what's on record. So with that, let me just I'll share my screen, and I'll give you a demonstration of the new Civics application. So this is Civics. I'll point out first of all that the way you get to it, the URL is rentcontrol.santamonica.gov. So rent control comes first in this case, so it's rentcontrol.santamonica.gov, and that will take you to our Civics login page. If you don't have a login yet, then you would come here, and at the bottom you see there's a create a profile link. You can click on create a profile, and you'll be directed to a form where you can enter information about who you are and where you live. For tenants, you'd be selecting tenant. Since this is both for property owners and tenants, so you wouldn't be asking for an account as a company. You can put in your email address. Obviously, there are some required fields here. Your first name, your last name. There wouldn't be a business address. Your street address, where you live. You can include the unit there. be helpful for us, or you can put it in the next field. That's also okay. And then it's going to be Santa Monica, of course, California, and your zip code and your telephone number. When you click next, the rest part, they're required fields, so I didn't get this. But the next page is really for property owners to enter the property addresses of the properties that they own. But when you complete this form, and I'll fake it for now, just enter something here. Address, 1985 Main Street. Well, I'll get corrected at the end, so we're good. One. Number 310-458-8751. And here's where I say it's really just for property owners and managers to enter information, but you do need to come to this page and scroll down to the bottom to submit. And you'll get a notice that your Civics user profile has been accepted. We go through these generally once a day, and we send an email back to you to say, okay, we have received your request. I'll point out, though, that this doesn't immediately create a Civics user account. We need to set that up for you in the back office. We'll do that. It may take a couple of days because we have a lot of them right now as we're just launching this system. But then we'll send you an email with a temporary password, and you'll use the email that you provided to log in. And then you'll be able to use Civics. And so let me show you what that would be. So again, the URL is rentcontrol.santamonica.gov. I already have an account, and I've asked it to remember me, so my email address is already here. For my password. And again. So this takes you to what will be your dashboard. And across the top, you'll see there's my dashboard, there's look up a record, and there's a submit a record. And in the case, I've signed in as a property manager with possibly some fees that need to be paid, or the annual registration fee. For tenants, there is never any fee here, so you don't have to worry about this. Will always be zero. Then my different projects show up on my my dashboard, and I can go to any one of those if I like. But if you are a tenant and you haven't recently filed a petition or one of the two types of fee waivers that I'm going to show you can file, then when you come here, you're not going to see anything. This is really kind of going forward, or if you are going to be filing a decrease petition or fee waiver application, that's when you would need a user account. Most tenants do not need a user account unless you're going to be filing something with us. There's really no value in it for you, to be honest. There's no information here that you wouldn't find elsewhere. It's really for you to submit a record with us. So at the top, you can see there's a submit a record button. So I'll click on that, and it's going to load the forms that can be filed in the system. Again, many of these are forms that owners are required to file, like a tenancy registration or, their ownership information, change of mailing address, authorized agents. They might have property managers. Some, exemptions down here. Tenants don't file for exemptions. But there are some of the fee waivers that we've mentioned before, the Clean Beach and Parcel Tax waiver, the low-income disabled tenant fee waiver, low-income senior fee waiver. So these three are filed by tenants. I think I said 2, 3. And then down here we have petitions. And so we have the decrease petition that can be filed by tenants as well. Probably the best case is that you've been communicating with one of the information coordinators or information analysts in rent control. before you file this petition, but if you know what you're doing, then that's fine. Each form begins with some instructions, and you can go out to our website as well and get more information about how to file a petition for rent decrease. But we do provide the basics on the form. Oops, I think I closed my form. Open. And as you'll see at the top, there are some tabs that show you where you are in the filing process. So right here, we're going to record information. And the first thing is, what property or which unit are we talking about? So, you file a decrease petition for your own unit, so you need to search that in the system. So you do that by adding a primary site, and then you can type in a property address. We suggest that you just enter the street number and the street name and the unit that you live in, and then hit search. The reason we limit it to this, you don't want to, if you add too many parameters, maybe you won't find an exact match. So you search, and then here at the bottom, you see the results for this search, and that's the one that I want. So I select my unit, and I say add unit, and it's added here. So you can confirm that your unit has been added to this record. And then you save and continue. There's no need to put any location details here. And our instructions, will explain all this. So you save and continue, and then you have these various sections, which can be opened or closed. We'll go through each one briefly. Basically, we have our form details, landlord and manager information, the conditions that you're having, maybe some reduced housing services that you're having, petition support. So there may be some things that, for example, if there were a code enforcement order about these conditions, then you could tell us that here. You can have a representative work with you on the hearing instead of being, representing yourself directly. And then there are some required attachments for, well, I'll get into it in a second, but then a certificate of information. So this is your signature, and this allows you to file this form online. Before we had civics, you would need to submit your forms on paper, or if it were email, with a digital signature. So let's just take a quick look at the form. Again, we want to check your street address and make sure that if there are any problems on that first screen where you're choosing the site, that we know where you live. We need to know all the petitioners. It could be that more than one petitioner is doing this. Maybe you have a couple roommates and both of you want to attend the hearing or be part of this. Then you want to list both of your names just by clicking the add button, and then you save the information. Tell us what your rent is, when you moved into the unit, if you're participating in the Section 8 program, if you have any scheduling, constraints, let us know that, because that helps us when we're scheduling mediation or the actual hearings. We need your landlord information so that we can contact them. And then here's a list of the typical conditions that most units have, and you can select the boxes of the conditions for which you would like to file a petition for rent decrease. As we explained in the instructions, you can only file a petition for rent decrease for those things that you have already noticed your landlord for. So you have to have given a written notice to the landlord, and then you have to wait at least 30 days. And that gives the owner the opportunity to address the conditions that you've identified. But if after 30 days you still have those conditions, you can contact us and we'll direct you to how to complete this form. And we just want to make sure that everything that you put on the petition is something that you have already noticed the landlord for. So these are very typical things like missing tile, maybe broken cabinets, maybe an elevator that's not working. We have paint on here, the damaged wall or ceiling surface, those kind of things, holes in walls. Kind of a lot of common things. If you have something that's not covered here, you can click other and enter it, give us, details. And then there may be some reduced housing services, like maybe the owner has taken away the parking, or you used to have owner provided furniture. That's an older thing. Security gates, these are generally things that are more related to the common areas of the property. Again, petition support, if you have anything to add here, a representative, and then we will require these attachments. So we need a copy of the notice that you give to the landlord. We also need a proof of service form. And we can send these to you so that we know when you gave this notice, the original notice to your landlord about the conditions, and now it's at least 30 days later. You have to file this within 180 days. Otherwise, you need to give a new, fresh notice to the landlord. But we first have you here just identify what you're going to attach, and then you fill in your information, your signature, and then you save and continue. I'm not going to fill in everything here, but I'll point out that when you go to the next tab, you'll see attachments. And there, it's very easy for you to just drag and drop, like the notice that you gave to your landlord or your proof of service form into this petition, and it will be uploaded. The attachment has to be in the form of a PDF. If you don't have a PDF, we can help you put that together and upload it for you, or send it to you for upload. But then you'll have a chance to review what you're going to submit and then ultimately submit it to us. Once you submit it, it will appear on your dashboard. And even though I've logged in here as a property owner, I'm able to file the decrease petition. Owners can file decrease petitions as well if they are taking away an amenity and they want rent control to decide by how much the rent should be reduced for that amenity. But you'll see it appears as a decrease petition on your dashboard. And you can, this one is in progress, but you would be able to go to it, and you could also see the status of this petition as it changes over time. But the main thing is that it allows you to file it online. So that's really it. But again, most tenants would not need a Civics account unless you're going to be filing one of those fee waivers that I pointed out for this decrease petition. I do want to follow up on the and give us a little minute for a question, but somebody had asked about the maximum income to qualify for one of our fee waivers. For a one-bedroom unit, for a single-person household, it's $33,600. For a two-person household, it's $38,400. For a three-person household, it's $43,200. And for a four-person household, it's $48,000. Again, those applications will need attachments of proof of income, and it's very similar to this decrease petition. And you'll have an attachments tab where you can drag and drop whatever supporting documentation that you have. So that completes the presentation of civics, and we've got one question, and that is there a way to check and see if a landlord has applied for Ellis Act or for permits to make changes to the property? Yes, probably the easiest way for that is to contact us. We don't have any of that information online. The notice of filing probably is scanned into the documents, but that may take some time. The best thing is for you to contact us. But if the owner does file an Ellis Act withdrawal with rent control, we are immediately in contact with you. So we will send you a letter, I think within 3 days, to let you know that it's been filed and what your rights are with respect to the Ellis Act withdrawal. And regarding permits, it probably would be best to check with the city's planning department, but some of those permits do come to us at Rent Control to sign off on if they might impact the property. So we got the info code schedule there. But the thing is, just call us and we can check for you or direct you over to planning, and you can check with them if there's any permits going on. So I don't see any other questions, and we have already reached 12:01. So again, I'll just repeat our website. It's santamonica.gov/rent control. We will be posting this seminar there. It may take a few days to get it up there. And then I want to remind everybody that there is that public hearing on June 9th regarding whether or not to impose a cap on the general adjustment for rents that are $2,325 or higher. So if you do want to comment to the board, send us an email at rentcontrol@santamonica.gov, or go to the website and go to the agenda for that meeting, and you can request a chance to speak to the board during the meeting. All right, that's it for today's presentation. Thank you all for listening and staying for 2 hours. If you have follow-up questions, please feel free to call us at 310-458-8751. And otherwise, the next you'll hear from us is a summer mailing regarding the general adjustment and the decisions of the board regarding whether or not to impose that cap. And you'll be receiving that at the end of June or the beginning of July. All right, again, thanks for joining us. Have a great day.